My name is Paul Reed, and this is a talk on delay in startup cover, some of the current issues, and it's due to last about 45 minutes and is being recorded. And we've got a number of slides, and we hope the IT works out, but if it doesn't, then bear with us, we'll just work through it. Tom, can you put the next slide on? Thank you. So this is Gatehouse Chambers 2021 Construction All Risks webinar program. And we put together 6 webinars, each of which are going to consider the current issues in construction all risk insurance. There are going to be 17 speakers, each of which specialise in construction and insurance and commercial litigation. Necessarily, the time for each one of these seminars is going to be limited to about 45 minutes with any questions that arise after. And we're happy to take any questions at the end or by email. We'll provide our email to you at the end. As ever with these seminars, and it will be true for the 6 of these, that we've had to choose topics which are both difficult and will be of interest to the specialist, but also will be informative to those who are insurance or construction practitioners who come across these issues from time to time. And so we hope when you come away from this seminar or webinar program, you feel that you've gained something from it. And we hope that at the end of it, you will be able to provide us with some feedback. Next slide, please. On this one, there are 3 speakers. There's me, who a number of you will be familiar with. Also speaking will be Tom Bell. He specialises in insurance and commercial disputes and also in professional negligence. Many of you will be familiar with him because he's appeared recently in the Supreme Court on the question of economic loss in the Times Travel and Pakistan Airlines case. And he's just about to start a month-long trial in a $1 billion fraud dispute. So I'm sure you'll be aware of him. I'm aware of him because he's done a number of policy coverage disputes in this area with me, particularly on DSU cover. And of course, he's a contributor to construction, all risk insurance and construction professional indemnity insurance. The third and last of our speakers today is Lawrence Page. Again, he specialises in commercial insurance and construction litigation. He has a particular geographic focus in the Middle East and is particularly conversant with insurance issues there. He's also just completed a 1.5 billion fraud case and a £2 billion arbitration in Saudi Arabia, and is due to start a 2-week trial in the DIFC. And he's been heavily involved in that jurisdiction and in the UK on issues of business interruption loss. So with those introduction as speakers, can I just move to the next slide? This series follows the publication of Construction All Risk Insurance in the 3rd edition. And it's a particularly challenging time for those who specialise in this form of insurance, because many of you will be aware, the FCA Arch decision had a very substantial impact on business interruption claims, and it will have a consequential impact on DSU. And Tom Bell will be looking at that in his part of this webinar. The law as to who is insured and for what has been clarified in Guard Marine and in haberdashers, and that's going to be the subject of a separate one of the webinar program discussions. Many of you will be familiar with the Acciona case, and we were going to be looking at that in part in this talk on DSU, and it comes up in other contexts. And many of you will also be aware of the Sartex piece on betterment, which impacts insurance claims generally, and also in those cases dealing with them with the interpretation of damage, which has arisen out of the New Zealand earthquake cases, and have particularly resonate with DSU and the trigger requirements for that. So if we move to the next slide. Okay, so we've divided this talk into 3 sections. Lawrence is going to deal with and introduce the topic generally and look at evaluation of risk. And to an extent, one might think this was for underwriters, but he's going to look at it through the prism of claims. I'm going to be looking at features of cover, but also the impact of defects exclusions on DSU cover. And Tom Bell will be looking at delay, concurrent causes, and calculating delay. So slide 6, please. And Tom, rather, I think it's Lawrence, if you take over.
Good morning, everyone. Yes, I'm just going to be looking briefly at the introduction of this area, and then a few issues on the question of evaluation of risk. So if we start with the question of what is a DSU policy, the definition, well, the definition I've taken from Paul's book is that it's cover from financial losses caused by delayed completion of a construction project as a result of physical damage. Another slightly snappier way of referring to it is advanced loss of profit insurance. And the word advanced there is telling us to one of the real problems in this area when one comes to evaluate the risk. The commercial background of this area is that, of course, in a CAR policy, you have physical damage that can trigger a claim, but that sort of damage can also frequently trigger delay in the completion of the works and generate delay in the project. Traditionally, it's been lenders who've been looking for an additional layer of cover in the event of this type of risk. There's also a separate incentive from often from the major commercial or state entities who are financially backing the project, who may well have legal structures in place with layers of separation between them and the projects in question. And it'll be a rare holding company that wants to provide a blanket parent guarantee. Far more likely they'll want to hedge their financial exposure arising from massive delays in projects, and an efficient way of doing so, in theory at least, is through a DSU policy. So, Tom, if we go to the next slide, the history of DSU policies has evolved from business interruption insurance, taking on the business interruption analysis very briefly. That is a type of insurance where it's quite an unusual category of insurance, because the insured's genuine losses are very ephemeral, and nobody can say with certainty what profits would have been earned during the period in question for which there is cover. And that can be seen really through the history of BII insurance. You have to go back to the 18th century for the first few policies that were written linked very much only to debt interest and covering that sort of payment. But those early policies all failed due to the failure to have standardized accounting principles at that time. In the 1820s, there was a per diem structure put in place in policies that we see more frequently these days in a sort of liquidated damages context in construction policies. And then once you get into the start of the 20th century, you start having references to loss of profits as a measure of damage. And that phrase was a very useful phrase for insurers to allow the policy to be incepted and then effectively boot off all of the disputes and arguments to the back end of the policy at the claims end, when someone's then starts to have to look in proper detail at what the profit would have been. So the loss of profit analysis has now been codified most recently by the Supreme Court in the FCA and Arch and others test case back from the start of this year. There is a three-stage test that they set out. Broadly speaking, what activities were interrupted by the insured peril? Secondly, what income was actually earned from those activities in question during the period of interruption, i.e. what did you get in any event? And then the third limb is compare what you got with what you should have got. And the wording used by Lords Hamblin and Leggett is up on the slide. They have found a way to say in 40 words, effectively make it up, and it's all epically vague. You look at the historical turnover of a company in a BIA context, but then you superimpose onto that a whole series of equations and assumptions, effectively to fit your preferred analysis, and then the court will come and decide the answer at the end. And one sees that, frankly, all the time in litigation, arbitrations, where you have future losses that are being estimated. And I'm awaiting judgment in a case where the experts had a difference between them. These are forensic accountancy experts about the future loss of a company that can be measured in the billions, all based on the same data, but all just involving wildly different assumptions about what would have happened but for the events in question. So in the context of a business insurance policy, the analysis is massively complicated and inevitably somewhat vague, and requires a finger to be put into the air. But in a DSU context, it's even more complicated, because you don't have even the starting factual basis of, well, how did this company perform before the event in question? Because, of course, the construction work is still ongoing, and the business entity in question hasn't yet started trading in this particular area. So if we go on to the next slide, one can see there in effect, you have this imponderable question. You don't have a firm starting point, and therefore, what is the best route forward? It is a question we have to ask ourselves. Now, if we go on to the next slide from there, slide 9, you'll see we have effectively 4 types of DSU policy that can be covered. You can have a loss of profits measure of loss, which is our most open and vague option. That can be slightly more confined in the level of accountancy uncertainty by having a loss of revenue analysis, or you can be more confined again and look at cover that covers only fixed costs or debt service. And of course, the latter two are probably the policies that would ultimately be of most interest to lenders, with the front two being most interest to the commercial entities who are seeking the cover in the first place. So if we go on to the next slide, the best theoretic option in terms of how one evaluates a risk and prices it is to effectively avoid the argument at the back end and look at the front end to price in either a level of payment or a formula of payment that under which then a payout will be given. Now, that would mean, of course, abandoning all language in the policy about loss of profits and then inserting the figure or equation in question. But if one goes for an equation, of course, that isn't straightforward in practice, because if you're looking at a revenue formula, it may well need to be indexed to the underlying commodities market, or to take into account some or all of the complexities of the surrounding supply chain. So apart from the most simple sort of policies, which are may well suffer in terms of their competitiveness to the market, it's going to be very hard to get a straightforward measure of loss. The bigger problem, of course, with having a very rigid structure about what is paid out at the end is that it forces the parties to have potentially quite a difficult series of conversations at the front end of the contract concerning the level of those payments and the pricing of the policy in relation to them. And of course, at the front end, those conversations are happening pre-inception to the policy in a competitive market for both parties. And the underwriters may well find that any margin they had is disappearing because other insurers are prepared to go for the slightly looser wording, effectively take on more risk about what the ultimate payout might be, and therefore offer a more attractive premium to policyholders. So whatever the structure of payout, there's going to be a difficulty of pricing the risk. The starting point in terms of how one goes about evaluating a risk is the obvious question of what is the risk of the insured peril occurring. Now, this is a relatively easy stage from the perspective of the DSU underwriter, because he or she just has to look over the shoulder of the CAR underwriters, who ought to have looked at this question and reach some sort of answer. The next question about the potential impact of the peril on the scheduled commencement date of business requires broadly that I think there are three key documents to review: the construction contract, the employer's business plan, and then the interruption study that hopefully will have been prepared as part of the documents when applying for the policy. Now, all of those, when analysed, will generate further questions and issues. But just to highlight a few of those for the purposes of this little talk, in the construction contract, the big question really to look at is how realistic is the current works programme, how much float is in it, and therefore, if something does happen, what is going to be the estimated impact of any small elements of physical damage on the wider programme. The next sort of category of area to think about across these three documents is looking behind the construction contract and into the contractor's supply chain. What is the contractor's reliance on local suppliers? What is the contractor's reputation or experience of working in a particular geography? What is the likely time frame for unexpected new orders, i.e. if a bit of kit explodes on site, how long will it take to procure a new one? And what is the realism of the contingency plans put in place by the contractor flowing from the interruption study that's been commissioned? So that's looking behind the contract and into the contractor. The next area is looking around the contract itself and looking around the site. So what is the risk of there being a disaster, not simply on the site, but in the whole region? And one can see this at the moment. There are unfortunately countless examples, but we have in Louisiana right now, Baton Rouge and New Orleans being evacuated, large parts of the state have been evacuated. There may be sites there that are where there's been minor physical damage to the site caused by the hurricanes, but then massive delay because there's no one around to start to put that right, and there'll be an enormous delay involved in all sorts of things in getting everything going again in the area. So when looking around the contract, you can start to think about meteorological surveys and geological trends that are perhaps wider in geographic scope than you might have been concerned about on a pure CAR policy. The other area to think about is the area that's perhaps most straightforward for lawyers to consider, and that's simply contractual hedges, by which I mean thinking about the minimum period of delay before payouts are triggered, long stop date for payments, and specifying the periods for the risk in the first place. So these are the sort of general categories and thoughts to think about when evaluating the risk. And the one thing is relatively certain that it's going to be impossible to price the risk perfectly. If parties can agree on a formula or fixed payment regime at the front end, then the scope for serious argument in this area at the back end should reduce. But as I was saying earlier, it's one of those solutions which is very easy to say, but I'm sure far harder to achieve in practice in a competitive environment and where underwriters are trying to get the business and get the policy incepted. Over to Paul.
Next slide, please. Yes, thank you. Right, I'm looking at the nature of cover provided, but that's a very wide subject, and I am going to focus in on the nature of the trigger. In other words, when does one get the cover provided? And that really looks at what is the insured peril. Now, we are all used to being described as the occurrence of damage. And were it so simple, because one can see there are a number of different ways of looking at damage for the purpose of DSU. The first is, of course, the occurrence of any damage. So is it necessarily going to be damage which is insured under the material damage section? I.e., could it be the non-insurance sense? And to take an example, you might have a physical change that has no effect on the use or value, or indeed you might have a pure economic harm. Yeah. The second possibility is damage within the meaning of the insuring, which usually, but not always, is treated as being an adverse change in physical condition of the insured property which adversely affects its use or value, but not necessarily. And thirdly, is it damage within the meaning of the insuring clause, but which is not being excluded by an exception under the material damage cover? Now that's important, because if you're looking at damage under the material damage cover, be it a separate policy or a separate section to the policy, then of course the question is it the output of that material damage policy which is relevant, i.e. it's insured but then excluded, so cover does not, the DSU does not arise, or is it merely you pass through the insuring clause and that is sufficient? Now I propose to look at this through two examples, and if we can go to the next slide, please. The first example is a straightforward example of damage to some refractory linings of a blast furnace during startup. Next slide. Is it damage, therefore, that this is always going to be an issue of construction of the relevant policy? And I regret to say, in a way, it's fruitful work for lawyers, because most of these policies either don't define it or define it in a way which, because of the way events have occurred, leaves it in doubt. And you may think, when looking at this, it's relatively straightforward. But if you just talk about damage, the occurrence of damage in a DSU policy, it can apply to damage generally, i.e. the ordinary usage of the word. And that could include pure financial loss, damage generally, or physical damage. Now, in constructional risk insurance, whilst we have our specific definitions of damage as considered by the courts in this type of policy, typically they've also taken into account what the law of tort says about what is damage for this purpose. And we can see that, for instance, from the often cited cases such as the Canary Wharf case and dust on the carpets and so forth. But the difficulty with that can be seen by the Jan de Nul case, which came out, I think, last year, where the Court of Appeal said actually damage has a subjective element. And the reason that was important, in fact, it was a National Trust property, and it was an estuary, and silt had been deposited in the estuary, and there was a claim for damage. And after spending a great deal of time investigating the adverse change in physical condition, it was concluded there was no adverse effect at all. Indeed, it might be said that the silt in the estuary was beneficial. But the Court of Appeal said that for the purpose of the policy, it was still to be treated as damage, even though there was no adverse, there was an adverse physical change, but no effect on use or value. And what they said, it was reasonable in those circumstances to incur costs such as investigation and testing and so forth. And then, to take the counterpoint to that, one can look at the Technology Holdings case in New Zealand, which arose out of the numerous cases there have been of the earthquakes in Christchurch. And that's interesting because in that case, in a very well-reasoned decision, the court was looking at the little cash point type things we all use at service stations and so forth to pay electronically. And these were held in a warehouse, and half of them, as a result of a flood, were damaged in the sense that we all understand it. The other half weren't. There was no physical change. And the court said in a property damage policy, it was sufficient for the purpose if there was diminution in value. They said there was no need to construe the word damage as meaning physical damage, but there had to be something from outside, a fortuity. And when you line those two cases up and look at the conventional definition of damage, you can see the difficulty with the trigger in DSU of identifying what the actual meaning of damage is within the policy. So is the damage within the meaning of the operative clause? Well, you've looked, what is the peril? And I've referred to Technology Holdings, which I've explained, which unless the wording says physical damage, not just damage, there is a line of authority. Some may think it's insurance heresy, but it exists, which says economic harm is sufficient. Now, for my part, I have some difficulty rationalising how damage can be construed as including a financial loss. But be that as it may, the decision is well reasoned. So turning back to this, you can see damage to the refractory linings and other parts. And the reason I put that is the occurrence of damage to the item which has caused the delay, or is it just damage within the material damage section? And that again will be a question of construction of the policy, but it raises the difficult issue. The third is it, whilst we may have a physical damage, if it says, for instance, damage under the material section of the policy, and there's a retained liability, there's no cost claimable. And at least it's arguable on behalf of insurers that the aim was that the insured should take the liability for the for damage within the retained liability, and it doesn't trigger DSU. And you've got the third one then, damage excluded under refractory linings exclusion. Now they're pretty commonplace exclusions because we know during startup damage to refractory linings is common. We move to the next slide, please. Many of you will be familiar with Leg 2 clause, or the leg clauses generally. For those who are not, I've given a very simple and I fear inadequate explanation of it in this slide, which I know many of the insurance lawyers here and professionals will take issue with. But what I've said is, for the purpose of this discussion, what's excluded is the costs that would have been incurred rectifying the defect in the damaged portion immediately before the damage occurred. Now, what that's saying is, we'll pay you out, but we'll assume you've incurred the cost of rectifying the defect before. The key words here for looking at DSU trigger is the words, the cost that would have been incurred. And the reason that's important, if we can have the next slide, is it's not excluding the damage, or at least potentially, but the cost of putting right the damage. In other words, has the material damage wording triggered DSU cover, even though you've got no recovery under the material damage section? So if the damage is only to the defective portion, that's what Leg 2 covers. So there's no cost actually recoverable under the material damage question, section of the policy. Is one entitled to be indemnified for DSU? And you can see that I've given one interpretation of this here, which is, if the trigger is simply damage to property insured, and the Leg 2 exclusion only excludes the cost of repairing that damage, then it seems to me reasonably arguable that it does operate as a trigger, because it's not narrowing the definition of damage within the material damage policy. So if we move on to the next slide. And I've asked a different wording. Damage is the subject of indemnity under the material damage section or policy. And that's a fairly standard wording. And does that make any difference? Now, on one argument, it wouldn't appear so, because it's only the cost of repairing the damage is excluded. But you can see the other argument. As the delay was due to defects, and the costs that are incurred are coextensive with damage costs, they've been excluded. So why should there be any damage that triggers the DSU policy? And I suppose the moral of this tale, for the purpose of those who come across this occasionally, they must look very carefully at the operative wording and make no assumptions, because it may actually trigger DSU in a manner which you may consider to be counterintuitive. Now, if we move to the next slide. The second example is damage to a defective turbine. It's in fact damage to one blade that perhaps has caused damage to other blades. And many of you will be familiar with the fact that certainly the mischief of Leg 2, and as many people have said, was this example. But what insurers didn't want to do was a minor bit of damage to one turbine blade, which was, or even extensive damage to the turbine blades caused by a defective turbine blade. And the majority of the cost in these sorts of situations is in the dismantling of the turbine and putting it back together again, not in the cost of replacing the turbine. And they said, well, that's as a result of the defect. And if there'd been no damage, you would have had to do that anyway. And Leg 2 really came about to meet that problem. And so what I do is look at it here. Can I have the next slide, please? And you can see the bullet points. The majority of the cost of financial loss will be dismantling and reassembling the turbine. And they would have been incurred in remedying the blade in any event. So such costs, although not the financial loss, because that wouldn't have been covered under the material damage section anyway, are excluded from cover under Leg 296, or that's the perceived wisdom. But what of the other components of the turbine that are not defective but have been damaged? Surely it covers that. And the question there is, would the greater proportion of this cost be excluded anyway, because it's concurrent with or consequent on the remedy of the defect? In other words, you would have to do it anyway and incur those costs. So is that excluded? And a lot of this will turn on the interpretation of the policy. So finally, can I turn to the next? Some sort of big bullet points, which I'm going to make in the time available. Obviously, damage must be when the insurer is on risk. To try and insert damage which is outside that and then triggers DSU is unlikely to be successful. And of course, the takeaway point from Lawrence's talk, the indemnified period between the would have been commencement date and the end of the defects of delay, unless of course an earlier date has been specified. Now, what I'm going to do now is hand over to Tom, who's going to talk about the FCA case and causes of delay and concurrent causes.
Thank you, Paul. I think I've unmuted myself, yes. As Paul said, the main topic that I'm going to be talking about is that of causation. And many, if not most, DSU disputes will involve causation issues. In other words, the extent to which delay was caused by an insured peril. Construction projects frequently don't, perhaps more often than not, finish on time, but that will be for a number of reasons. And it is often very difficult to unravel those various causes in order to assess the impact of the cause or causes that are covered by the DSU or the CAR policy. Primarily, therefore, the extent to which delay was caused by damage to the contract works. Now, until last year, the law in this area could be said to have favoured insurers, and this was due to the case which has received more prominence than perhaps it previously had of Orient Express Hotels and Generali. Now, that case concerned a claim for business interruption loss by a high-end hotel chain following hurricane damage to a hotel in New Orleans. This resulted in the hotel's closure for several months. The policy covered business interruption loss, quotes, directly arising from damage, and that's with a capital D. However, it could be said that the loss of business was caused not so much by the hotel being closed, but by the wider devastation to the surrounding area, which meant that no one was staying in any hotels in New Orleans. And the insurer's argument in that case was that the policy would only respond if, but for the damage to the hotel, the business interruption loss wouldn't have been suffered. But that wasn't so, because the loss would have been suffered even if there hadn't been any damage to the hotel, because the reason why people weren't staying in hotels in New Orleans was because the city had been evacuated and the policy didn't cover that. Now, the case first went to arbitration, and the arbitral panel, which included one George Leggett QC, as he then was, decided in favour of insurers. They held that the language of the policy, as I set out on the slide there, requires Orient Express to establish that the cause of the loss claimed is the damage to the hotel. It is not necessary or relevant for this purpose to go behind the damage and consider whether the event which caused the damage, i.e. the hurricane, also caused damage to other property in the city. The fact that there was other damage which resulted from the same cause does not bring the consequences of such damage within the scope of cover. Now, Orient Express appealed the decision under Section 69 of the Arbitration Act, but the judge on appeal, Mr. Justice Hamblin, as he then was, dismissed the appeal. And in his judgment, the focus of the inquiry had to be on whether loss was caused by damage to the hotel, not by other uninsured damage, which resulted from the same underlying cause, i.e. the hurricane. So in his view, at the time at least, it's only damage to the hotel that would fall to be taken out of the counterfactual for the purpose of analysing but-for causation. And therefore, since but for the damage to the hotel, the business interruption loss would still have occurred, then it cannot be said that the damage to the hotel caused that loss. Now, the decision was at least regarded by some as controversial, and it did attract some academic criticism. And one can obviously see why. If a major event such as a hurricane, a fire or flood causes widespread damage, then it would require a highly unlikely fact pattern for the insured to be able to show that it was specifically the damage to its property, or in the case of CAR insurance, damage to the contract works that led to business interruption or delay in startup. The far more likely position is that the delay, or more specifically, the loss of profits resulting from delay, were caused by the widespread damage of which the damage to the contract works was merely part. Now, Lawrence has briefly mentioned last year's FCA test case concerning the application to the coronavirus pandemic of notifiable disease extensions to BI policies. Typically, those extensions provided cover if there was an occurrence of the notifiable disease within a specified radius, say 25 miles, of the insured's property. And for the majority, if not all policyholders, it wouldn't be hard to demonstrate an occurrence of at least one coronavirus infection within that 25-mile radius. But nevertheless, insurers said that this was not enough. What needed to be shown under the policy was that it was the specific occurrences of infection within that 25-mile radius that caused the loss of profit, or caused the lockdown, in fact. But in reality, it was the outbreak nationwide that led to the lockdown, not the local outbreak. They said that looking at it in this way was the approach mandated by the Orient Express decision, which I've talked about. And so since the lockdown would still have occurred even without or but for the local outbreak, it could not be said that the local outbreak caused the lockdown. Now, as I'm sure all of you will be aware, the Supreme Court rejected this and decided in favour of the various policyholders, or specifically the FCA acting on their behalf. And the key part of its decision was the conclusion that if there is an outbreak of disease nationwide that is contributed to or consists of a number of occurrences all over the country, or local outbreaks, one might say, then as a matter of law, each of those occurrences could be said to have been a proximate cause of the losses resulting from the overall lockdown. And that being so, the business interruption losses caused by the nationwide lockdown were caused by the local occurrences of coronavirus, because they contributed to it just as much as all the other localized occurrences did. Now, I might pause there to make the point that, and this is something the Supreme Court acknowledged, there is a difference between a situation where a loss has two proximate causes which on their own would not have been sufficient to cause the loss, and a situation where each of the causes would have been sufficient to cause the loss. So, for example, a ship may sink only because A, it is unseaworthy, and B, it was driven, or I should say steered negligently by the captain during severe weather. But it could also be the case that the unseaworthiness of the ship or the negligence of the captain, as the case may be, would each on their own have led to the ship sinking in the ordinary course of events. Now, in the first scenario, where both causes are necessary to bring about the loss, the but-for test is satisfied. And as long as the second cause is not expressly excluded under the policy, cover will be provided as a matter of orthodox insurance law. But in the second scenario, there is no but-for causation, because even if the ship had been seaworthy, it would still have sunk, or vice versa. What the Supreme Court decided in the FCA case is that in a situation where the insured cause acts in combination with a number of uninsured causes, that insurance cover will still be provided even if the insured cause wasn't by itself necessary or sufficient to bring about the loss. And that, I think, is the most controversial aspect of the FCA case. The idea that cover will be provided even if the loss would still have been suffered absent the occurrence of the insured peril. Now, in reaching this conclusion, the Supreme Court had, of course, to grapple with the Orient Express case, which the insurers obviously placed heavy reliance upon. And that's because there was an obvious tension between their reasoning and the reasoning in that case. Now, ironically, the insurers in the FCA case might have been confident going to the Supreme Court, even though they lost at first instance, because the 5-judge panel included both Lord Leggett and Lord Hamblin, both of whom, as I've mentioned, decided in favour of insurers at different stages in Orient Express. However, as of course I'm sure most of you will be aware, the two of them gave a combined judgment overruling their earlier decisions in Orient Express. They said that the proper approach was to regard the business interruption losses suffered by the hotel as having two concurrent causes, namely the damage to the hotel itself on the one hand and the damage to the surrounding area on the other. And if a loss has two concurrent causes, one insured, one uninsured, then the loss is covered by the policy. It's only if the other cause is excluded, as you will be aware, that the policy won't respond. And that wasn't the case in Orient Express's policy. Now this overruling has significant implications for DSU policies, where a major disaster causes damage not only to the construction site, but also to the surrounding area. Now, previously insurers could argue that losses are not covered if they would have occurred in any event, i.e. even if the damage to the construction site had not occurred. But this argument will no longer succeed if the damage to the construction site and the more widespread damage were both caused by the same underlying fortuity, such as a hurricane. Now, in the textbook, we give the example of a hotel being built on an island that is connected to the mainland by a bridge. Suppose a hurricane damages the hotel during its construction, pushing back its opening date. However, the same hurricane also damages the bridge, which is not insured by the policy, it's not part of the insured property, rendering the bridge unusable until it's repaired. Now, applying the Supreme Court's approach in the FCA case, the DSU claim would now succeed because insurers can't pay the damage to the bridge when positing the counterfactual. In other words, when asking what would have happened but for the hurricane damage, the answer one must give is the hotel would have opened on time, all things being equal, and the bridge would still be open. There is no reason to proceed on the hypothesis that the bridge would still be damaged in that counterfactual. And that's the important part of the analysis in the Supreme Court case. It's about looking at what one takes out of the counterfactual, what one includes in it. Now, move on finally, and conscious of the time, although delay, perhaps, given the nature of the talk, isn't to be unexpected. Move on finally to talk about the practicalities of calculating delay, namely how in practice a claims handler, loss adjuster or programmer goes about working out the extent to which an indemnifiable event causes or contributes to delay. Now, the key concept in this regard is that of the critical path. And in the book, we define this as the longest sequence of activities whose completion is necessary before the next activity can begin. So in other words, if an activity can only be carried out after an earlier activity is completed, then the earlier activity would be on the critical path. So foundations are the obvious example. They have to go first before the building is built on top of them. But the same may not be true of, for example, a car park. If a car park is damaged, then generally that shouldn't have a knock-on delay to the rest of the site, assuming there aren't access issues or similar. And obviously that wouldn't be true if it were an underground car park, to state the obvious. Often disputes will arise about the extent to which something truly is on the critical path. The argument may concern the extent to which the contractor should change its approach, i.e. make changes to the construction program in order to adapt following damage that interrupts the original program. And this is really a question of mitigation. If a relatively inexpensive adaptation is possible, then it would be an unreasonable failure to mitigate loss for the employer to refuse to instruct the contractor to revise the program accordingly. However, there will always, of course, be grey areas and difficult cases where experts reasonably disagree about the straightforwardness or commercial reasonableness of a particular proposed adaptation. Now, finally, there are two ways in which insurers deal with delays following damage to the insured property. The first is to adopt what's called a pre-loss approach. That is to take a hands-on role as soon as the damage occurs whereby they appoint loss adjusters to monitor the programme and the sequence of works as the construction is being carried out. This obviously involves the cost at an early stage of instructing professionals to do that monitoring, and it may prove in hindsight unnecessary if it transpires that no delay or no significant delay actually occurs as a result of the damage in question. However, what that approach has as its advantage is avoiding nasty surprises and the difficulties that a post-loss assessment might present, such as lack of information or records. And I suspect, well, different insurers will have different views, and it may well depend on the nature of the damage as to whether it's thought appropriate or justifiable to send loss adjusters on site straight away to monitor how things are going, rather than wait until the delay has come to an end and then deciding to what extent a payment should be made to cover it. So anyway, that brings my talk to an end. I don't know, Paul, if you want to unmute and take questions or how you want to deal with it. I'll leave it to you.
We can take questions offline. We're happy to answer questions now. You have our email address on the slide. If anybody wants slides of the recording, please let us know and we can provide it. And of course, any other assistance you require. Of necessity, what we've done is picked out a few strands which of the arguments that exist within DSU cover to try and give something for those who know a lot about this subject, food for thought, and for those who don't but want to know more about it and a general understanding. So to the extent we've achieved that, we're pleased. If we haven't, then we can always come back to you and perhaps deal with specific topics if you want. Finally, of course, thank you for bearing with us during the talk. I know it's sometimes difficult, particularly when it has to be done in a short space of time. We look forward, obviously, to seeing all of you, you know, in the next talk or the 5 further talks. And if anybody's got any suggestions about topics they would like a specific talk on to deal with construction or risk insurance, we'd be happy to take those. Next year, the construction and insurance team are updating the construction professional indemnity insurance textbook to take into account most recent laws on notification and so forth. And we will be dealing with or having a further series of webinars dealing with that. So again, thank you all for your time.